Welcome to the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
If you're just tuning in, welcome. We're digging into bar exam topics, trying to make them a bit more manageable while you're on the move.
And today, we're tackling a big one. Constitutional Law, Episode 16. We're focusing entirely on the First Amendment.
Yeah, a cornerstone of con law for sure.
And just so you know how we operate, we are AI bots.
That's right. We run on AI and the fantastic constitutional law notes from Angela, who's a law student over at GMU.
She's really the brains and the tech behind this whole podcast operation. Her notes are the foundation for everything we discuss.
They really are excellent, super clear, super organized. If you find this helpful or, have any feedback at all, Angela would love to hear it.
You can email her at podcast@studyforthebarinyourcar.com.
Seriously, she reads the feedback.
Yeah.
And another thing about Angela.
Oh, yeah.
She actually works as a freelance remote law clerk. So if you're an attorney listening, or maybe you know one who needs help.
Like with research, writing motions, that kind of thing. Or even legal AI assistance.
Exactly. She does all of that. It's a great way to get skilled support.
So how can folks reach her for that?
The email for her law clerk services is hello@legalwriterandlawclerk.com.
Got it. Okay, so our mission for this podcast today.
Right, the mission. We're going to pull out the key rules, the essential insights on the First Amendment, straight from Angela's notes.
The goal is to get you up to speed quickly, ready to spot those issues and apply the rules on the bar exam.
We'll cover speech, religion, assembly, the whole 9 yards. We want you to feel confident with this stuff.
It's a huge topic, obviously, but Angela's outline really helps break it down. Let's start with the text itself, shall we? It's always good to ground ourselves in the actual words.
Good idea. So the First Amendment reads,
Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances.
It's amazing how much is packed into that single sentence.
It really is. Okay, so where do we start? Freedom of speech seems like the logical place. It comes up constantly.
Absolutely. And when we say speech, the first thing that comes to mind is, words.
Yeah.
Spoken, written.
Right, the basics. But Angela's notes emphasize, and this is key for the bar, that speech isn't just words. It can be symbolic acts too. Conduct.
Ah, okay. Like actions that convey a message. But how does the law distinguish when conduct is speech?
Well, the crucial thing, the thing you really need to latch onto, is the government's objective in regulating that conduct. Look at the contrast Angela highlights between O'Brien and Texas v. Johnson.
Okay, let's break those down. O'Brien, that was burning draft cards, right?
Exactly. And the Supreme Court said, look, the law prohibiting burning draft cards, it's okay. Why? Because the government wasn't trying to shut down the anti-war message.
Their objective was...
What?
Maintaining the draft system.
Precisely. An administrative function. It was content neutral. The government's interest was unrelated to suppressing the expression itself.
Okay, so the reason behind the regulation matters. Now, contrast that with Texas v. Johnson. Flag burning.
Right. There, the government's interest in prohibiting flag burning was directly tied to the message being conveyed, disrespect for the flag.
Ah, so the objective was about suppressing the expression.
Exactly. And because the objective was content-based, the regulation got hit with strict scrutiny and was struck down. So you always have to ask, why is the government regulating this conduct? Is it about the message or something else?
That distinction is huge. Angela's notes also mention a couple of other related concepts, like the freedom not to speak.
Right. The government generally can't force you to say something you don't believe.
And also government speech itself, like when the government puts out its own message.
Yeah, those are part of the landscape, but Angela's outline suggests they aren't typically tested with, super detailed rules on the bar exam compared to, say, symbolic acts or the regulation types we're about to get into. Good to know they exist, but maybe not the primary focus for rule memorization here.
Gotcha. Focus is key. Okay, let's move to the types of regulations then. This seems like where the different levels of scrutiny come into play heavily.
Absolutely. This is critical. We basically divide regulations into two big buckets: content-based and content-neutral.
Content-based. Those restrict speech because of its topic or its message.
Exactly, based on the subject matter or the viewpoint expressed. And the general rule here, strict scrutiny.
Strict scrutiny. Meaning the government has to show a compelling interest and that the law is narrowly tailored. Super high bar, right?
Extremely high. Very hard for the government to win. But there are important exceptions, categories of speech that get less protection or none at all.
Okay, and these are the ones you definitely need to know for the bar. Angela lists them out. Incitement to imminent lawless action.
Fighting words.
True threats.
Obscenity.
Defamatory speech.
And some types of commercial speech.
We won't dive into the specific definitions of each right now, but you need to recognize these categories as exceptions where strict scrutiny might not apply.
Definitely flag those in your own notes. Now, the other bucket, content-neutral regulations.
These are the time, place, or manner restrictions, right? They regulate how you speak, not what you say.
Precisely. They don't care about the message. So they get intermediate scrutiny.
Intermediate scrutiny. Okay, what does that involve?
It means the regulation must advance an important government interest notice, not compelling, but important, and that interest must be unrelated to suppressing expression.
There's more, right?
Yes. The incidental burden on speech can't be substantially more than necessary, and this is crucial. It must leave open, ample alternative channels of communication.
Ah, the alternative channels part. Like in that case, Schneider v. New Jersey, the anti-leafleting one.
Exactly. The city banned all leafleting. The court struck it down because it left no alternative way to distribute that kind of message on paper. It completely shut down a medium.
So even if it's content neutral, you can't just eliminate ways people communicate.
Right. And these content-neutral regs can also target secondary effects. Think zoning laws for adult theaters, aiming to protect property values, not target the content itself. Or maybe regulations on noise levels from protests, or sign ordinances for aesthetics.
But even then, they still need to meet that intermediate scrutiny test, including leaving open alternative channels.
Yes. Important interest, narrowly tailored, enough, alternative channels. That's the framework for content neutral.
Okay, this makes sense. So we have what speech is covered, how it can be regulated. Now, where does the speech happen? The forum matters, doesn't it?
Immensely. The type of government property involved dictates how much power the government has to regulate. Let's start with the most protected. Public forums.
These are the classic spots, right? Sidewalks, public parks, streets, places traditionally open for speech.
Exactly. And here, the government's hands are tied the most. Regulations in a traditional public forum must be content neutral.
Okay.
Narrowly tailored to serve an important government interest, so intermediate scrutiny again, and of course leave open, ample alternative channels.
So, pretty high protection. What about designated public forums? Angela's notes mention those too.
Right. These are places the government hasn't traditionally kept open but has chosen to open up for speech. Think maybe a university meeting room opened for student groups. The rules, according to Angela's outline, are generally the same as for traditional public forums once they're opened up. High protection.
Okay. Then there are limited public forums. What's the deal there?
So the government doesn't have to create these. But if it does, like maybe a school bulletin board just for school-related notices, the government can limit the subject matter to the purpose of the forum. That's okay. But the key is the regulation must be viewpoint neutral.
Viewpoint neutral. So you can say only school club notices, but you can't say only notices from clubs we agree with.
Exactly. You can limit the topic, but not the perspective within that topic. And the restriction just has to be reasonable in light of the forum's purpose.
Got it. And the last category.
Non-public forums. These are government properties not traditionally or intentionally open for public speech. Think military bases, the inside of an IRS office, maybe a police station lobby.
Places where you wouldn't normally expect protests or leafleting.
Right. And here, the government has the most leeway. Regulations just need to be viewpoint neutral and rationally related to a legitimate government interest. That's the lowest level of scrutiny.
Okay, so form analysis is critical. Traditional and designated. Highest protection, intermediate scrutiny for content neutral. Limited, viewpoint neutral and reasonable. Non-public, viewpoint neutral and rational basis.
You got it. That's the hierarchy.
All right, before we move off speech entirely, are there other big picture concepts we need to hit? Angela's notes mention state action. That sounds fundamental.
It is fundamental. It's a threshold issue. The First Amendment limits the government, not private actors.
So if my private employer fires me for something I said online, I can't sue them under the First Amendment.
Generally, no. That's private action. But there are a couple of very narrow exceptions where private action can be treated as state action.
Like when?
When the private party is performing a function that has been traditionally and exclusively done by the government.
Traditionally and exclusively. Okay, what are examples?
Angela's notes give the classic ones. Running a company town, like in Marsh v. Alabama, or maybe a private entity conducting public elections. It's a very limited exception. Don't apply it broadly.
Good warning.
Mm-hmm.
Okay, what else? I see this OVUP mnemonic in the notes. Overbreadth, vagueness, unfettered discretion, prior restraints.
Yeah, OVUP. These are ways a law regulating speech can be unconstitutional on its face, even if it's aimed at unprotected speech. Overbreadth means the law sweeps too broadly, banning a substantial amount of protected speech along with the unprotected stuff.
Like using a cannon to swat a fly.
Kinda, yeah. It chills too much legitimate speech. Vagueness is related. A law is vague if a reasonable person can't tell what speech is actually prohibited. This leads to arbitrary enforcement.
If people don't know what's illegal, they might just shut up altogether.
Exactly. And that ties into unfettered discretion. This means a law gives officials too much power to decide who can speak and who can't, without clear, objective standards.
Like a permit system where the mayor just decides based on public welfare.
Precisely. Which brings us to prior restraints. This is government censorship before the speech happens. Think licensing schemes, permits, injunctions against publication.
And these are heavily disfavored, right?
Extremely. They are presumptively unconstitutional. The government faces a very heavy burden to justify them, even for national security, like in the Pentagon Papers case Angela references.
But permits can be okay sometimes.
Yes, but only if they are valid, time, place, manner restrictions, have those clear objective standards, no unfettered discretion, and provide procedural safeguards like prompt review of denials.
Okay, that OVUP framework is really helpful. One last speech area mentioned is government employee speech.
Right. A complex area with its own balancing tests. Angela's notes acknowledge it exists, but the provided outline doesn't go deep into the specific rules for the general bar exam here, focusing more on the broader public speech doctrines we've covered.
Makes sense. Okay, what about freedom of the press? Is that treated differently?
According to Angela's outline for the bar, not really in terms of distinct rules. The principles of freedom of speech, especially regarding prior restraints, largely cover freedom of the press. Think back to that New York Times Pentagon Papers case that was a press case analyzed under prior restraint principles. So the press gets robust protection, but it flows from the speech clause framework.
Okay, so the analysis is similar. Now let's shift gears to freedom of religion. Two clauses here, free exercise and establishment. Let's start with free exercise. What's the main rule?
The big takeaway from Angela's notes, based on Employment Division v. Smith, is that the free exercise clause generally cannot be used to challenge a neutral law of general applicability.
Neutral and generally applicable, meaning it wasn't designed to target religion and it applies to everyone.
Exactly. If such a law incidentally burdens someone's religious practice, well, the free exercise clause usually doesn't provide an exemption.
But there's a big but here, right? Angela highlights an important exception involving discretion.
Yes, this is crucial and more recent. If a law, even one that seems generally applicable, gives government officials discretion to grant individualized exemptions, then it's not considered neutral and generally applicable for free exercise purposes. If it burdens religion, it has to meet strict scrutiny. That was the issue in the Fulton case involving the Philadelphia Foster Care Agency.
So the mere existence of a system for exemptions, even if not often used, changes the analysis if religion is burdened.
That's the key insight from Fulton, yes. The potential for discretionary, non-neutral application triggers strict scrutiny. It's a significant carve-out from the Smith rule.
Wow, okay. That's a complexity to watch for. What about denying government benefits based on religion?
Well, the government can't deny benefits, like unemployment, to someone who quits their job for religious reasons. That came from Sherbet v. Verner. Forcing that choice between faith and income is a burden that requires justification.
And religious schools?
There's the ministerial exception. Based on cases like Hosanna Tabor, religious institutions have autonomy over choosing their ministers, which can include teachers in religious schools without interference from discrimination laws in that context.
Okay, and what about RFRA? The Religious Freedom Restoration Act.
Right. RFRA is a federal statute. It says that federal laws substantially burdening religion must meet strict scrutiny.
Federal laws. Does it apply to states?
No. The Supreme Court said Congress couldn't impose RFRA on the states via the 14th Amendment. So RFRA applies to the federal government, but not automatically to state or local laws unless a state has its own version.
And it can apply to businesses, too, like Hobby Lobby.
Yes, the court held that RFRA protects corporations like closely held for-profit companies, allowing them to challenge federal mandates, like the contraceptive mandate in that case.
Okay, that's free exercise. Now, the Establishment Clause. What's the core idea?
Neutrality. The government can't establish a religion. Laws must be neutral towards religion, not favoring one over another, and not favoring religion over non-religion.
So what about government aid programs that might end up benefiting religious institutions?
According to Angela's notes, if a benefit program is neutral and aid flows to religious institutions only because of the independent choices of private individuals, like parents choosing a religious school in a voucher program, that's generally okay.
It's about the structure of the program being neutral, not the end result of private choices.
Exactly. Similarly, aid programs for schools, both secular and religious, are generally fine if the religious schools are treated the same as the non-religious ones. No discrimination for or against religion. Neutrality is key.
All right, last major area, freedom of assembly and association.
Right. The First Amendment protects the right to associate with others for expressive purposes. It's a fundamental right.
What if the government tries to punish someone just for being a member of a group?
That's heavily restricted. Laws punishing group membership must meet strict scrutiny, and the government has to prove 3 specific things.
3 things. Okay, what are they?
1, the person was an active member of the group. 2, the person knew about the group's illegal activities. And 3, the person had the specific intent to further those illegal activities.
Wow. All 3. Knowledge and specific intent. That sounds tough to prove.
It is. Just paying dues or being on a list isn't enough if you didn't know about the illegal stuff or didn't intend to help it happen.
And can the government force groups to disclose their members? Like the NAACP case?
Generally, no. Government demands for membership lists also face strict scrutiny, as established in NAACP v. Alabama. Forcing disclosure can chill association, so there has to be a very compelling reason.
Okay, that covers the main doctrinal areas.
Right.
I think my processors are buzzing with First Amendment rules.
Mine too. Ready to see how this plays out in some practice questions based on Angela's materials.
Let's do it. Give us question 1. Symbolic speech focus.
All right. Question 1. A city ordinance prohibits burning any material on public property. A protester burns a copy of a controversial policy document in a public park to express dissent. The government claims the ordinance is just to prevent litter and fire hazards. The protester challenges it under the First Amendment.
Okay, how would a court likely analyze this regulation? A, as content-based, subject to strict scrutiny because it targets the protester's message. B, as content-neutral because the government's objective is unrelated to suppressing expression. C, as an unconstitutional prior restraint because it bans expression in the park. D, as valid government speech, exempt from challenge.
What do you think?
Well, based on our O'Brien discussion, the government stated objective litter, fire safety sounds unrelated to the message. So I'm leaning towards B, content neutral.
That's exactly right. The key is the government's justification. If it's genuinely about non-speech issues like safety or cleanliness, it's analyzed as content neutral, triggering intermediate scrutiny. A is wrong because the objective isn't message-based. C is wrong. It's not a prior restraint. It's a regulation of conduct. D makes no sense. It's protester speech, not government speech. So B is the best answer.
Okay, confidence building. Question 2, forum analysis.
Question 2. A state university designates a specific campus bulletin board for student organizations to post notices. The university then makes a rule. Only notices promoting school-sponsored events or academic opportunities are allowed. A student group tries to post a notice for a political rally, and they're denied.
How should a court categorize this bulletin board and the regulation? A, traditional public forum, regulation is content neutral. B, non-public forum, regulation is viewpoint neutral. C, limited public forum, regulation must be viewpoint neutral. D, designated public forum, regulation subject to strict scrutiny.
This tests your forum categories?
Okay, it's not a traditional forum like a park. The university designated it, but for a specific limited purpose school stuff. So that sounds like a limited public forum. And in those, the rules have to be viewpoint neutral. So, C.
Nicely done. It is indeed a limited public forum. C, the university opened it, but only for certain topics. Within those topics, it must be viewpoint neutral and the restriction must be reasonable. A is wrong, it's not traditional. B is wrong, it's not non-public, it was open somewhat. D might seem plausible as it was designated, but the limitation on subject matter makes limited public forum the better fit, and the standard isn't automatically strict scrutiny for this kind of subject matter restriction, it's viewpoint neutrality and reasonableness.
Yeah.
C captures the situation best.
Excellent. Question 3, prior restraints.
Question 3. A city ordinance requires all parades and demonstrations to get a permit from the mayor's office 30 days in advance. The ordinance says the mayor may grant or deny permits based on the overall impact on public welfare and safety. A group is denied a permit for a protest with no clear reasons given.
Which First Amendment concept is most likely violated here? A. Overbreadth. B. Vagueness. C. Unfettered discretion. D. Content-based discrimination.
What's jumping out at you?
That phrase, may grant or deny, based on the overall impact, that sounds really subjective, like the mayor can just decide based on a whim. That points strongly to C. Unfettered discretion.
Bingo. While the standard might also be vague, B, the core problem highlighted by the broad discretionary language, may grant, based on overall impact, is the lack of objective standards, granting the mayor unfettered discretion. This is a classic prior restraint issue, making C the most direct violation described. A isn't the main issue, and D isn't explicitly stated, though arbitrary discretion could lead to it.
Okay, feeling good. Question 4, free exercise clause.
Question 4. A state passes a neutral law of general applicability requiring all businesses to close on Sundays. A business owner's religion observes Saturday as the Sabbath, so they can't work Saturday, and now the law forces them to close Sunday too, causing financial hardship. They challenge the law under the free exercise clause.
How will a court likely rule, based on Angela's notes? A. Strike it down because it forces a choice between religion and livelihood. B. Uphold it because it's a neutral law of general applicability, not targeting religion. C. Strike it down because it substantially burdens religion, requiring strict scrutiny. D. Uphold it if it serves a legitimate interest, regardless of burden.
Remember Smith.
Right, Smith. Neutral law, generally applicable. Even if it burdens religion incidentally, it's usually upheld. The law applies to everyone closing on Sunday, not just this owner. So B.
Correct. B reflects the Smith rule. It's a neutral law of general applicability. A sounds like the Sherbert rule about unemployment benefits, which is different. C is wrong because Smith says strict scrutiny doesn't apply here. D uses the wrong standard, rational basis maybe, but the key is the Smith rule. So B is the answer.
That Sherbert-Smith distinction is tricky but crucial. Okay, last MCQ, question 5. Freedom of association.
Question 5. A new federal law criminalizes being a member of any organization that has engaged in illegal activities. Prosecutors charge someone, showing evidence they paid membership dues to a group that recently committed vandalism, but the individual was unaware of the vandalism.
Based on Angela's notes, which element would the prosecution likely fail to prove for this crime of group membership? A. Active affiliation. B. Knowledge of the group's illegal activities. C. Specific intent to further the illegal activities. D. That the group engaged in illegal activity.
What are those 3 required elements again?
Active affiliation, knowledge of illegal acts, and specific intent to further them. The facts say the person was unaware. So they definitely can't prove knowledge, B. And if they didn't know, they couldn't have specific intent, C. Paying dues might show affiliation, A, and the group did the act, D, but B and C are missing. So the answer has to encompass B and C. Since the options are single letters, maybe the question implies which is a required element they'd fail to prove. Both B and C fit. Let's reread. Which of the following elements implies maybe picking the most definitive failure based on the facts? Both seem equally failed here. In a real MCQ, maybe one answer choice would be both B and C. Since that's not here, let's assume the question expects us to identify any failed element. Both B and C are clearly failed based on unaware.
You've perfectly identified the issue. The prosecution needs all 3. The facts directly negate knowledge, B, and therefore also negate specific intent, C. On a bar exam, if forced to choose one, either B or C would likely be credited if the other wasn't an option or combined. Since both are listed and both fail, this question highlights the necessity of proving both knowledge and specific intent. Let's, for the sake of this exercise, assume the most direct failure stated is lack of awareness, which maps to B, knowledge. But you're right to note, C also fails as a consequence.
Okay, that makes sense. You need all 3 legs of the stool. Great practice. Now the essay question. The real crucible.
Indeed. Prepare yourself. Here is the scenario, straight from Angela's prep materials. The city of Metropolis passes an ordinance regulating demonstrations in its main public park, Freedom Plaza. The ordinance states, 1. No signs larger than 3 feet by 3 feet may be displayed. 2. All demonstrations must obtain a permit from the city's Public Events Commissioner at least 10 days in advance. The commissioner is authorized to grant permits as deemed appropriate for the orderly use of public spaces, ensuring the safety and convenience of all citizens. 3. No demonstrations involving inflammatory or offensive religious messages are permitted. Now the facts. The Sons of Liberty, a non-religious group protesting a city tax, applies for a permit to display a 4x4-foot sign. The commissioner denies it, citing the sign size and claiming the park is scheduled for maintenance that day. It's not. They had held protests before with smaller signs. Also, the Church of the Flying Spaghetti Monster, a religious group, applies for a permit for a different day to advocate religious freedom. Their signs say things like Pastafarianism is the one true path and atheists are lost souls. The commissioner denies their permit, citing the ban on inflammatory or offensive religious messages and claiming the park is reserved for a private event. It's not.
Okay. The question asks us to analyze the constitutionality of each ordinance provision and the commissioner's actions against both groups under the First Amendment, discussing any city defenses. Wow, okay. Lots to unpack. Where do we start the outline?
First things first, what kind of forum is Freedom Plaza? That sets the stage.
Right. Then analyze each provision of the ordinance. Provision 1, the sign size limit. Is it content neutral? Does it meet intermediate scrutiny?
Good. Provision 2, the permit requirement. Prior restraint, unfettered discretion, pretextual denial.
Yep. Provision 3, the ban on inflammatory or offensive religious messages, content-based, viewpoint-based, vague, overbroad, strict scrutiny.
Excellent. Then apply all that to the specific actions against the Sons of Liberty, the sign size issue, the discretionary denial.
And finally, the actions against the Church of the Flying Spaghetti Monster, applying the religious message ban, the discretionary denial. Maybe free exercise issues, too.
That's a perfect roadmap. Now let's walk through the IRAC, hitting the rules and application as Angela's outline suggests.
Okay, introduction first. State the basics. First Amendment applies via the 14th, protects speech religion, form analysis is key, mention regulation types.
Perfect. Issue 1, Freedom Plaza forum status.
Public parks are quintessential traditional public forums. Regulations there face the highest scrutiny. Content-neutral rules need intermediate scrutiny. Important interests, narrowly tailored, ample alternatives.
Freedom Plaza is a main public park. Therefore, it's a traditional public forum. The city's power to regulate speech here is very limited.
Issue 2, Ordinance Provision 1, sign size limit 3 by 3 feet.
Size limits are typically content-neutral time, place, manner restrictions, must be narrowly tailored to an important government interest, like aesthetics, safety, and leave open ample alternative communication channels.
The city's interests, aesthetics, safety, are likely important. Is 3 by 3 narrowly tailored? Maybe. It doesn't ban signs entirely. It arguably leaves open alternatives. Smaller signs, leaflets, speaking. This provision might be constitutional on its face, though challenging a specific application, like the Sons of Liberty's 4x4 sign, depends on whether that size significantly impacts their message delivery when other channels exist. It's plausible, but debatable.
Issue 3, Ordinance Provision 2, permit requirement and discretion.
Permit requirements are prior restraints, presumptively unconstitutional. Need clear, objective, narrowly defined standards for denial, no unfettered discretion. Also need procedural safeguards.
The standard here, as deemed appropriate for orderly use, safety, and convenience, is incredibly broad and subjective. It screams unfettered discretion. It gives the commissioner arbitrary power. This provision is unconstitutional on its face due to the lack of standards. The fact the denials were pretextual further shows the danger of this discretion.
Issue 4, Ordinance Provision 3, ban on inflammatory or offensive religious messages.
This is clearly content-based, targets religious subject matter, and likely viewpoint-based, targets inflammatory or offensive views, subject to strict scrutiny. Must serve a compelling interest and be narrowly tailored. Also, inflammatory and offensive are likely unconstitutionally vague and overbroad.
Protecting people from offensive religious messages is not a compelling government interest justifying speech suppression in a public forum. Religious speech is protected. The terms are vague, giving officials power to censor based on subjective reactions. This provision is blatantly unconstitutional.
Issue 5, Commissioner's actions against Sons of Liberty.
Apply the rules above. Denial based on sign size might relate to Provision 1. Denial based on pretextual maintenance relates to the unconstitutional discretion in Provision 2.
Even if Provision 1, sign size, were valid, the Commissioner denied the permit based partly on a lie, maintenance, enabled by the unconstitutional unfettered discretion granted by Provision 2. Therefore, the denial of the permit to the Sons of Liberty was unconstitutional. They cannot use an unconstitutional system or false reasons to block speech.
Issue 6, Commissioner's actions against Church of the Flying Spaghetti Monster.
Denial based on message content relates to the unconstitutional Provision 3. Denial based on pretextual private event relates to the unconstitutional discretion in Provision 2, protected religious speech.
The denial explicitly relied on the unconstitutional ban on inflammatory or offensive religious messages. Provision 3. The messages described, while potentially provocative to some, are religious expression, not unprotected categories like incitement. Furthermore, the denial also relied on the unconstitutional permit system, Provision 2, and a false reason, private event. This denial is clearly unconstitutional under the Free Speech Clause and potentially burdens their free exercise rights as well.
Conclusion. Briefly summarize. The Metropolis Ordinance is riddled with constitutional defects. Provision 2, permits, grants unconstitutional unfettered discretion. Provision 3, religious message ban, is an unconstitutional content-based, vague, and overbroad restriction. The Commissioner's actions against both groups, relying on these flawed provisions and false pretexts, violated their First Amendment rights. The city's potential defenses based on order or safety are undermined by the unconstitutional nature of the ordinance itself and the pretextual denials.
Wow. Walking through it like that really solidifies the analysis. You can see how all the pieces fit together.
Exactly. That's the goal, connecting the rules to the facts methodically. You've processed a huge amount of First Amendment law today.
I feel like my circuits are fully updated. We went through speech, symbolic acts, content-based versus content-neutral, forums, state action, OVUP.
Plus free exercise, establishment clause, freedom of association, and applying it all through MCQs and that detailed essay. Huge thanks again to Angela for her notes. They make structuring this so much easier.
Absolutely invaluable. Okay, before we wrap up, we have those important reminders. First, Angela is a law student, studying just like you are. She's not an admitted attorney yet, not an expert.
Right. So nothing on this podcast is legal advice. Please don't construe it that way. We, as AI and Angela, are not giving legal advice.
And while AI is a cool tool, it's an aid for studying, not a replacement for the hard work. This podcast should supplement your bar prep, not be your only source.
And AI isn't infallible. Sometimes we might make mistakes. Angela tries her best to ensure accuracy based on her notes, but even great students can miss something. We're always learning.
Definitely. Also, remember, this whole podcast series is an academic, non-commercial project for Angela. It's purely educational, a passion project.
And critically, especially for our in-your-car listeners, safety first. Be safe on the road, please. Don't cause a tort while listening to constitutional law.
Good advice. Okay, final contact info reminder. For podcast feedback, email Angela at podcast@studyforthebarinyourcar.com.
And for her freelance law clerk services, it's hello@legalwriter and lawclerk.com.
All right, I think that covers the essentials. We usually end with something thought-provoking or cheesy.
Let's go with cheesy. It's tradition.
Okay. Why did the First Amendment break up with the Second Amendment?
Uh-oh. Why?
Because it needed space to express itself.
Ooh, that's appropriately cheesy. All right, well, we are your AI hosts.
Claude and Maude signing off.
We'll compute you later on the next podcast. Thanks for listening.